Be ready. 5 seconds to go. The faulty repair to the transformer resulted in a loose connection that led to the catching of fire to the transformer, and all the cars in the parking lot were burnt in the fire, which resulted in suffocation for viewers of the cinema in the hall. Further, it was held that in that case there was an addition of an eight-seater box that closed off the exit on the right side of the balcony. It was also found that the owners of the cinema have added 52 additional seats to the theater, which blocked the gunway on the right side of the movie hall. In the aforesaid case, both A1 and A2 were found guilty not by virtue of their position in the company but rather by virtue of specific allegations made against them. In the aforesaid case, accused themselves were found to be occupiers. There were gross statutory violations which had a direct nexus with the death of the victims. Further, looking at the facts and circumstances of the present case, the said case cannot be applied against the appellants accused. Having regard to the case law referred above, by applying the facts of the case on hand, we are of the view that the case of the appellant accused number 2 Shiv Kumar Jatia in CRL appeal at the rate SLP serial number 8008 of 2018 falls within one of the categories enumerated in the case of State of Haryana versus Bhajan Lal to invoke the inherent powers. Rather, Section 482 of the CRPC, either to prevent the abuse of the process of court or otherwise the secure the ends of justice. In the criminal appeals at the rate SLP serial numbers 10054 10056 of 2018, the sister of the victim has also questioned the directions issued by the High Court allowing them to appear before the trial court through an advocate and by permitting them to appear as and when there is a specific direction by the trial court to appear before such court. It is the case of the appellant complainant in the above said criminal appeals that while dismissing the criminal miscellaneous cases filed under section 482 of CRPC, the High Court has committed error in issuing directions as referred above. It is the case of the said appellant that to dispense with personal appearance and allowing the accused through an advocate can be considered by the magistrate under section 205 and or 317 of CRPC, but without recording any reason the High Court has issued such directions which are impugned in the appeals.